My name is George Parnham. I'm an attorney, board certified. I've been practicing for 48 years here in the state of Texas, specializing in the area of criminal defense law. Lately, I have been involved in a number of cases involving the insanity defense. The insanity defense is very difficult, and it's made very difficult initially because of the insanity standard that we have to deal with is part of the code in our state. The insanity standard is very archaic. Basically, it calls for an individual to be severely mentally ill, but that's not enough. An individual must know that he or she is doing is not wrong based on that mental illness, and it gives the state the opportunity to bifurcate, to agree that mental illness exists, but the individual still knew what he or she is doing is wrong. Unfortunately, it permits the state and experts to come in and to give objective opinions as to whether or not the person knew what he or she is doing is wrong. There's no definition of what the word "no" means that goes to a jury. There's no definition of what the word "wrong" means that goes to a jury. As a consequence, what happens is that the expert takes the stand, agrees and stipulates that the individual is severely mentally ill, but still applying the objective standard of knowledge, knows that the individual that committed the act, even though severely mentally ill, knew that it was wrong, and as a consequence is not applicable for the insanity standard to be a part and parcel of the defense. And the state will argue that, and has argued it many times. Unfortunately, it's my belief that the whole thought process of a mentally ill person to include decision making on the part of the mentally ill is part and parcel, not bifurcated, just one simple standard. Mental illness is a real world in which decisions are made by the individual who is suffering from severe mental illness, and those decisions are based upon the reality of the individual's mentally ill world.